Assalamualaikum and greetings to Professor Madya Dr. Sa'dan bin Man. Today, we would like to present ruling on adhering, which is iltizam, to a particular mazhab. First and foremost is the definition and understanding on mazhab, taqlid and adherence, which is iltizam to mazhab. My name is Aqilah. On this slide, I will define and brief in understanding of mazhab, taqlid and adherence to mazhab, which is iltizam. Firstly, literal meaning for mazhab is something intended or used as an upbringing, which is ma yuzhab ilayhi. Mazhab in Islamic jurisprudence is the teaching institution of Islamic law and can be considered as the compilation of all the rulings to be practiced and made as a fatwa. This knowledge connected with the teaching of companions, which is al-sahabah. For the second part is iltizam. Iltizam can be defined in two ways, which is the first one, some usuliyin say one is bound by his mazhab, where one is attached to one mazhab only. Meanwhile, for the second part is the strong opinion supported. Adherence of the mazhab is unbound absolutely, where in some circumstances, in Malaysia, most of the laws follow mazhab Shafi'i. But in paying zakat fitrah, one can follow mazhab Hanafi by paying with money instead of a rice. Meanwhile, taqlid can be defined literally as to follow or to imitate. Taqlid is commonly used to describe lay pupil who accepts a religious ruling from a certified and reliable scholar without questioning his textual proof and legal logic. They believe that ijtihad that have been made based on Al-Quran and As-Sunnah. For the second part is the background and history of taqlid and adherence to mazhab. For background and history of taqlid and adherence, which is iltizam to a particular mazhab, is divided in two periods. The first period is before codification of mazhab. During this period, laypersons are permitted to accept the opinions of different and multiple mujtahids because there is no access to a comprehensive codified set of laws. Additionally, broad dimension of scholar technique were often unified among scholars belonging to a specific town such as Mecca and Madinah. During the second period, after the codification of mazhab, during second hijrah, the emergent school of thought of mazhab Shafi'i, Maliki, Hanafi and Hanbali. The third hijrah, most of lay people and scholars who are not mujtahids need to make taqlid. And the fourth hijrah, the government began to follow a particular madhab. For instance, Islamic jurisprudence of mazhab Hanafi have been used as judges' take in the court during Abbasid dynasty. This period necessary for lay people to adhere on a particular mazhab to avoid them choosing any rulings according to their lusts.
And I'm Hannani, and we're moving on to the significance and function of existence of mazhab. So there are several important roles of mazhab in society. So this mazhab or school of thought acts as an institution that will systematically arranges and compile the Islamic law. It indirectly connects society with the demand of both Quran and Sunnah. And this is critical as not everyone in the society is able to understand the call and inquiry from the aforementioned sources directly. The establishment of this mazhab makes it easier for Muslims to understand the laws easily and clearly. As for the general public, following to this mazhab provides a convenient space to precisely practice the daily routine of Muslim law without being overwhelmed by the differences in opinion of the scholars. This mazhab or school of thought also shows the process of inferring and deducing Islamic law with the use of various methods and methodology of ijtihad by its scholars. This same process was also experienced by various other mazhab such as Hanafi, Maliki, Hanbali. It is well noted that the texts of Quran and Hadith are not practiced literally and carelessly. It is only after we analyze the content, examining the rationale of the law, connecting it with the objectives and purposes behind the Islamic ruling, which is our maqasid syariah, that the law was conveyed to the general public. This is particularly important so that Shariah's claim and law will not bring a burden to Muslims. It is also of particular importance for us to create harmony. Determining the Islamic law does not end with a review of the validity status of a hadith alone. The analysis held by the scholar also depends on the mastery of Arabic language, consideration of local customs, and differences in opinion with the other scholars. Other than that, Mazhab is of great significance to discipline public with knowledge and practices related to Islamic law consistently. So the General Secretary of Ikatan Ilmuwan Ahli Sunnah wal Jamaah Islami said that sectarian practices made the society more disciplined and systemic in religion. By sectarianism, the general public will be able to know the things that make a law valid or invalid, and actions that should be followed or should be abandoned. Consequently, they will be aware of the fatwa in their mazhab that may be different from the other. The harmony and differences of opinion will also be better managed in a sectarian context, unlike the case if there is no particular mazhab, and this will undermine the consistency of knowledge. This mazhab is capable of resolving an issue in a peaceful manner, ensuring that differences of thought do not persist and lead to negative consequences. Meanwhile, Datuk Dr. Muhammad Izhar Arif Muhammad Kashim, a senior lecturer of Center of Contemporary Fiqh and Sharia Compliance, Faculty of Islamic Studies, Universiti Kebangsaan Malaysia, said that our community in this country has yet to reach an open level in accepting all mazhab. As he said, the public must first understand the law of each mazhab before being allowed to accept the views of other mazhab than Shafi'i, which is held by the majority in this country.
The ruling of taqlid with mazhab. In the matter of ibadah or worshipping, Muslims have agreed that the Quran and the Sunnah remain as the two main sources of Sharia which must be obeyed and practiced. Originally, every Muslim was obliged to take the rulings of Allah subhanahu wa ta'ala directly from the two main sources, the Quran and the Sunnah. However, reality proves that not all Muslims are able to issue the hukum or rulings directly from the Quran and Sunnah. Apparently, only a handful are capable and qualified to do so, like the Imams and the four sects who are Imam Hanafi, Maliki, Shafi'i, and Hanbali. Imam Al-Ghazali said in his book Al-Mustasfa, the scholars of Usul agree that when a person has ijtihad and has obtained a law based on his strong allegations or zon, then he should no longer taqlid to other mujtahids who violate his ijtihad. The level of a mujtahid is certainly not equal to those who are not able to perform ijtihad or are called the public, which means knowledgeable to practice the available Islamic laws but not able to extract each ruling from its source. Next is the views on the ruling of taqlid with madhab. Here, there is a difference of opinion among Muslims. It is divided into two major groups. The first group is a group of usul scholars who think that sectarianism is haram. Here, Muslims are obliged to follow what is in the Quran and Sunnah directly without the mediation of madhab. Among the scholars who hold such an opinion are Khajandi, Nasiruddin al-Albani, and Ibn Hazm. The second group is the majority of usul scholars who opine that sectarianism for the public is permissible. Even for pure lay people, sectarianism is obligatory. They only differ in opinion on whether to follow the mazhab in the sense of taqlid or ittiba. As for the haram opinion, some of the usul scholars even claim that the followers of the four mazhabs are kafir or infidels and bid'ah, heretics. And among the al-usuliyin, regarding the opinion on permissibility, the law of taqlid for the public is divided into three views or opinions. First is from Mu'tazila in Baghdad, Zahiriyah, and part of the Imamiyah. They said it is haram to do taqlid and it is obligatory to perform ijtihad. The second opinion is from Al-Kiyaharasi and several others, and they said it is obligatory to follow a certain madhab only. And the third opinion is from Ibn Burhan and Al-Nawawi. It is obligatory to follow the madhab, but it is not obligatory to commit to any madhab. Like shifting madhab is permissible.
For the first opinion, Al-Ghazali and Ibn Qudamah said, this view is clearly contrary to the consensus of the Sahaba or the companions, which does not forbid the public to follow different scholars. And for the second opinion, according to this view, a muqallid follows a madhab in a fiqh problem because he thinks the madhab is correct. Therefore, he or she must practice that belief. Next is about the arguments and deduction on the opinion that sectarianism is haram. So the first argument is this opinion is contained in a treatise entitled Hal al-Muslimu mulzamun bi'ittiba'i madhabin mu'ayyanin minal madhahib al-arba'ah, which is written by Muhammad Sultan al-Ma'sumi al-Khajandi al-Salafi. According to al-Khajandi, Islam is nothing more than a collection of laws that can be counted and are very few which can be understood by every Arab or every Muslim. And indeed, the madhab are nothing more than the opinions of scholars in understanding a problem. For these opinions, neither Allah nor His Messenger obligates anyone to follow them. The second argument, also from Al-Khajandi, who said, whoever adheres to all the opinions of Abu Hanifa, Malik, Shafi'i, Ahmad or others and does not adhere to what is in Al-Sunnah, then it means he has violated the consensus of the Ummah and followed the path not taken by believers. Ibn Hazm as well opined the similar stance inside his book Al-Muhalla. Islam that is obligatory to be followed by everyone should not be taken except from the Quran and the authentic of Sunnah. And what can be deduced from these arguments is this statement is similar to the statement of a German Orientalist named Koch, who is known as a person who is very hostile to Islam. He once said, indeed, Islamic jurisprudence compiled by the Imams of the Madhab is a work of law of the creation of a special brain that is based on the book and Sunnah. And the Khazandi's treatise was quoted by Dr. Said Ramadan Al-Buti in his book entitled Alla Madhabiyya Akhtaru Bida'atin Tuhaddidu Al-Shari'at Al-Islamiyah, who concluded that all Khazandi's opinion is very misleading and dangerous. Next is the arguments and deduction on the opinion that sectarianism for the public is permissible. So why is the sectarianism is permissible for the public is because of the verse in the Quran, Fas'alu ahla dhikri in kuntum la ta'lamun, which means, so ask the people of the message, in other words, former scriptures, if you do not know. This is from Surah Al-Nahl, verse number 43 and Al-Anbiya, verse number 7. In the above verse, Allah subhanahu wa ta'ala instructs anyone who does not know about something to ask those who know. This shows that human beings are divided into two groups, namely the alim, pious, and the jahil, ignorant. For the ignorant, they are required to ask the pious about things they do not know when needed. The second argument is the ijma' or consensus of the that they give fatwas to the people without telling everyone to strive to reach the level of mujtahid. This matter is already known among the scholars and the public. The scholars as well, obliging the public to become mujtahid is impossible because it will cause chaos in public life. All worldly jobs and activities will be abandoned if everyone, including those who do not have expertise in the field of Sharia, is forced to study Sharia law until they are able to perform ijtihad whenever a problem arises. So the deduction of this opinion is based on Wahbah al-Zuhaili, who said, Taqlid should not be banned or obligatory because it needs to consider some current situations today, such as one's ability to perform ijtihad and their respective fields of expertise. As for the public, they have no choice but to follow the scholars because their ability to perform ijtihad is very limited. While the scholars, even if they do not reach the level of mujtahid, they should not be strictly bound by the fatwas or of the madhab. They are obliged to examine every law of fiqh and accept fatwas that have valid evidence and reject which ones are weak without being fanatical to a particular madhab. Next is the arguments and deduction on the opinion that sectarianism for the public is permissible, but only focus to the opinion from Al-Qiyaharasi and Ibn Burhan and Al-Nawawi. So the first argument is based on the Usuliyin, who said Muslims who have not reached the level of mujtahid must follow a mazhab. For them, there is no difference between the terms taqlid and ittiba', which means to follow the opinion of a mujtahid or madhab by knowing the legal basis of his opinion. Both give the same conclusion that the sectarian is needed. They also do not differentiate between the pure public and the knowledgeable, but have not yet reached the level of mujtahid. Both are still considered as public. The duty of the public is to ask the scholars, namely the mujtahid. The second argument is from Al-Amudi, who said the public and people who do not have the expertise in ijtihad, even if they can produce some knowledge that is mu'tabar in ijtihad, he must follow the opinion of the mujtahids and adhere to his fatwas, according to the Ahlu al-Tahqiq, or expert analysis of the usul scholars. Mustafti, fatwa question, needs to get a fatwa from a mufti, fatwa giver, who is knowledgeable and fair. If there is only one mufti in a place, then the mustafti must follow him. If there are many, he can ask anyone. However, according to Al-Ghazali, he himself encouraged the mustafti to seek the pious and the best mufti because the position of the mufti is like a proof or evidence for him. So what can be deduced from these arguments is based on some of the usuliyin as well. Some usuliyin say that one is bound by his mazhab. Yet according to the opinion that is considered strong, the commitment of the mazhab is not absolutely bound. It is not an offense for a person to follow Abu Hanifa in one problem and then follow another mujtahid. According to Al-Amidi and Ibn al-Hajib, the practice of taqlid to a particular madhab is permissible because since the time of the first mustafti within the Sahaba is not static with only one mufti, they are free to ask anyone.
So we're moving on to the canonization of Shafi'i sect in Malaysia. So currently, the realities of fatwa in Malaysia show that Shafi'i school of thought is an official mazhab as stipulated in the enactment of the administration of Islamic law in most states, where every fatwa decision must be based on the final opinion of this mazhab. Therefore, all citizens are obliged to follow the ruling of this fatwa of Shafi'i's mazhab. Such compliance is binding on all people in the context of collective legal interaction. If there are still parties who refuse to comply, they can be prosecuted, not for the freedom of following other denomination, but for violating the provision of law under the authority of the government. The emphasis on this matter is stated, among others, in the Enactment to Administration of the Religion of Islam State of Meaning, Enactment 2004, on the appointed of Mufti, authority in religious matter, the Fatwa Committee and Fatwa relating to matters of national interest, Section 54, Qaul Muqtamad to be followed states, in issuing any fatwa under Section 48 or certifying an opinion under Section 53, the Fatwa Committee shall ordinarily follow the Qaul Muqtamad, accepted views of Mazhab Shafi'i. Generally, this is also what's stated in the other state as well. However, Perlis is the only state that differs from other states in Malaysia in terms of its attachment to Mazhab Shafi'i. So in Enactment Number 4 of 2006, Administration of the Religion of Islam Enactment 2006, Part 3, the appointment of Mufti, authority in religious matter, the Fatwa Committee, and Fatwa relating to matter of national interest, Section 54, sources to be followed, states, in issuing any fatwa under Section 48 or certifying an opinion under Section 53, the Fatwa Committee shall follow the Quran and Sunnah Rasulullah sallallahu alaihi wasallam. Following these states, in issuing any fatwa under this part, the Majlis and the Fatwa Committee shall have due regard of adat istiadat Melayu or Malay customary law applicable in the state of Perlis. Based on several provisions of the enactment and ordinance as above, people of Perlis who reside in other states must abide by the fatwa of Shafi'i that has been decided. Similarly, the people who living in the state of Perlis must abide by the official fatwa of the religious authorities there on the basis of compliance to the government and the law. In conclusion, as the practices based on Mazhab Shafi'i have been so long and ingrained or cultured in the Muslim community of this country as a factor of compatibility in the association of community members, it needs to be maintained and nurtured, especially among the general public.
So we're moving on the views on the law of taqlid towards the madhab which is more relevant with the nowadays context. To view on this matter, majority of the public layman is not able to do tarjih and ijma to issue a hukum for every problem that arises in daily affairs. In other words, they are incapable to reach the status of mujtahid. So, without the qualifications to become a mujtahid, they may tend towards tatabu' ar-rukhas, simply following the most easy legal opinions without any shari'i needs. This is impossible to be prevented unless they are restricted to adhere or iltizam to a single madhab. Hence, as a sad az-zara'i, closing the avenues to impermissible ends, they are required to adhere to a single madhab. In other hands, since there are learning opportunities nowadays for some Muslim students, which make them pious and knowledgeable but still incapable to reach the level of mujtahid, they are required to ittiba' rather than taqlid. They don't blindly follow the madhab, but rather they may know the dalil for that particular hukum or know the reasoning behind the hukum, understanding the maqasid syariah, the objectives of Islamic jurisprudence, and such and such. So, to conclude our overall discussion, since most of nowadays Muslims are incapable of deriving hukum solely, they are obligated to be restricted and adhere to one single madhab. Second, every Muslim should be encouraged to learn and discover the knowledge of Islam, particularly the fiqh, because it really affects our daily lives. And third, for those who could not reach the level of mujtahid and are ambiguous on a particular problem, they should seek for trustworthy scholars such as muftis and refer to them. This is as Allah had mentioned in Al-Quran, Surah Al-Anbiya, verse 7, فَاسْأَلُوا أَهْلَ الذِّكْرِ إِن كُنتُمْ لَا تَعْلَمُونَ. So ask the people of the reminder if you do not know. That's all from us. Thank you for your attention and have a nice day.